In December 2020, the SEC sued Ripple Labs for issuing and selling unlicensed securities to the public. The Ripple vs. SEC lawsuit is still unfolding, and its findings will stand as guidelines for the cryptocurrency industry's future. Welcome to the Crypto Nights channel. If you love making money and learning about crypto, make sure to subscribe to the channel and hit the notification bell. We drop new videos every day to keep you informed about crypto. Who is Ripple? In 2011, three engineers, David Schwartz, Jed McCaleb, and Arthur Brito, began developing the XRP ledger. Fascinated by Bitcoin, they set out to create a better version that improved upon its limitations, with the goal of creating a digital asset that was more sustainable and built specifically for payments. Despite the revolutionary ideals of many of Bitcoin's early believers, Larson never thought blockchain technology should be used to overthrow the existing financial system. He believed that history's most transformative innovations have always relied on the great ideas that came before them, not displacing them. Since 2015, Ripple has tried to convince banks to use XRP as a means to transfer funds overseas. In 2016, Ripple hired former Yahoo COO, Brad Garlinghouse, to help them find a killer use case for XRP, and he did. Garlinghouse started pitching XRP as a bridge currency for global money transfers to financial institutions and banks. When used for international transfers, banks would need to hold reserves of minor currencies that would block the bank's funds. Furthermore, the banks would need to hold that particular currency only momentarily, simultaneously increasing XRP's liquidity and price. Ripple had partnerships with MoneyGram and Santander, and it was soon one of the big players among the financial institutions. This also raised the price of XRP from less than 1 cent to over $3 in January 2018. In comes the SEC. This caught the attention of the Securities and Exchange Commission. The governmental agency said that Ripple released $1.3 billion worth of unlicensed securities to the public. Moreover, it names Larson and Garlinghouse as defendants, the top names of the Ripple team. Stephanie Avakian, director of the SEC's Enforcement Division, stated that, "We allege that Ripple, Larson, and Garlinghouse failed to register their ongoing offer and sale of billions of XRP to retail investors, which deprived potential purchasers of adequate disclosures about XRP and Ripple's business and other important long-standing protections that are fundamental to our robust public market system." The Ripple vs. SEC lawsuit caused XRP's price to drop dramatically from 58 cents to 21 cents in December 2020. However, it did rebound later in 2021. Now for a little clarity, we will give you a history on securities in the United States, to help provide context of the current situation of Ripple versus the SEC. What is a financial security? A security does not have a utility and is a tradable financial asset representing some form of ownership in a corporation or a similar entity. For instance, publicly traded companies represent shares as securities, often to raise capital. There are three types of securities: equity, debt, and hybrids. Together with public sales, securities are regulated by the SEC. Companies, partnerships, or trusts issuing equity securities give the owner an ownership interest in the assets of that entity. A debt security is a financial instrument that represents money that has been borrowed. The terms specify the loan amount, annual percentage rate, maturity period, when it must be repaid, and other conditions. What makes a security for the SEC? What is a security for the SEC is somehow unclear, given the fact that in 2019, the agency publicly stated that Bitcoin is not a security, arguing that the SEC do not believe that current purchasers of Bitcoin are relying on the essential managerial and entrepreneurial efforts of others to produce a profit. In determining whether a token is legally a security, the SEC uses the Howie test. What is the Howie test? The SEC versus Howie was a Supreme Court case in 1946 that has a pivotal role in securities-related cases. It helps determine if a transaction is an investment contract as stated in the Securities Act of 1933. In 1946, two individuals from Florida were sold parts of their Citrus Grove land. They offered the option to lease the land back to the sellers. They would serve the land, harvest, and market the products and share part of the profit with the landowners. However, the SEC sued them for not filing a securities registration statement. The Supreme Court ruled that the contract was an investment contract, and it set the following guidelines to be used for future cases. There is an investment of money. The investment needs to be in a company or project. A common enterprise where the investors pool in their money and assets to invest in a project. Profit is expected. The profits come from the efforts of the promoter or third party. Although the Howie test uses the term money, it is used for other kinds of investments and assets. A key point in declaring an investment contract a security is the control of the investor over the profit. If the investors have no control over that asset, it is usually deemed to be a security. For a cryptocurrency to be classified as a security, it needs to meet all the criteria mentioned in Howie's test. How does the Howie test apply to Ripple? The Howie test admittedly has vague guidelines. The SEC concluded that XRP complies with the requirements of the Howie test. Ripple Labs, the company, sold $1.38 billion worth of XRP tokens. Investors bought XRP because they believed they were investing in a common enterprise. Ripple's marketing promotion and supply manipulation made investors believe that XRP's price would rise due to the company's efforts. Ripple vs. SEC lawsuit, a timeline of events. December 21, 2020. The SEC initiated the lawsuit against Ripple Labs, CEO Brad Garlinghouse, and co-founder Chris Larsen. Allegedly, Ripple Labs is selling unregistered securities, instead of a commodity, in a centralized environment. The SEC is accusing the two Ripple Labs execs of selling over 14.6 billion XRP tokens as means to fund the company and get rich. Ripple Labs CEO, Brad Garlinghouse announced that they will defend themselves in court. December 28, 2020. Coinbase, the largest cryptocurrency exchange, announced the delisting of the XRP token. March 3, 2021. Ripple Labs execs, Garlinghouse and Larsen, sent letters to the U.S. District Court Southern District of New York magistrate in pursuit to get Judge Sarah Netburn to dismiss the lawsuit Ripple vs. SEC. They argue the lack of fair notice and due process. March 8, 2021. The SEC responds by sending a letter to the judge to strike fair notice defense, seeking a hearing immediately. March 22, 2021. Judge Netburn told the SEC her understanding of XRP is, not only does it have a currency value but it has a utility, and its utility distinguishes it from Bitcoin and Ether. April 13, 2021. SEC Commissioner Hester M. Peirce published the Token Safe Harbor Proposal 2.0. The updated proposal seeks to provide a 3-year grace period for developers to find a way to simplify participation in a decentralized network, in which they would be exempted from the securities law. June 14, 2021. The court granted the SEC's motion to delay the disclosure of SEC's internal communications about Bitcoin, Ethereum and XRP until August 31. Internal documents on other cryptocurrencies may shed some light on the general view of the SEC on cryptocurrencies. The court has yet to rule if they want the SEC to disclose their internal trading policies around cryptocurrencies. August 31, 2021. The deadline for disclosing the SEC's internal documents. October 15, 2021. Expert discovery deadline for collection of what experts in the field of cryptocurrencies and securities have to say on the matter. December 8, 2021. The nonprofit organization, Empower Oversight file a Freedom of Information Act complaint against the SEC in regards with its potentially illegal market manipulation to hike Ethereum and Bitcoin, while slashing the price for XRP with a lawsuit. December 10, 2021. Due to conflicts in schedules of various experts and of the counsel responsible for those depositions, the parties have appealed the court to grant them till January 19, 2022, 3 business days after the existing close of expert discovery. January 8, 2022. The SEC made a surprise attack on the Ripple case by filing a letter of supplemental authority to strike Ripple's fair notice defense. The SEC had taken John M. Fife and 5 entities controlled by him to court in September 2020 for selling $21 billion of penny stocks and gaining a profit of $61 billion without registering as security dealers. Fife's defense adopted an argument similar to Ripple's, alleging the SEC hadn't given them a fair warning and the term dealer can be widely interpreted. Last month, the court denied this argument. What does it mean for the Ripple case? Naturally, the regulator now aimed to use this denial to strike at Ripple's fair notice key defense. Similarly, Ripple's fair notice defense alleges the regulator failed to notify them about a possible violation of federal securities laws and claimed the term investment contract is being misused by the SEC, adding that the SEC's theory, that XRP is an investment contract, is wrong on the facts, the law and the equities. The SEC is using the Fife case latest outcome to insist that the term investment contract is bound by legal parameters since 1946. However, the cases have distinct terms. The attorney Jeremy Hogan explained via Twitter that the Fife case outcome marginally helps the SEC's position in its motion to strike Ripple's fair notice defense, so the SEC filed it with the court. Although the SEC is trying to make a move out of the similarities from both cases, Hogan claims that FIFES was in a very different stage of litigation and the standard is completely different than the SEC v. Ripple case. Where are we now? Attorney Jeremy Hogan, a proponent and U.S. legal counsel for XRP2 project, believes that the case could draw to a close soon. Brad Garlinghouse, CEO of Ripple, is hopeful that the Securities and Exchange Commission's (SEC) case could close in April 2022. This is not for certain, as the close of expert discovery is coming up on January 19. Speculation ranges from a settlement being reached between the SEC and Ripple, the case being dismissed, or even being dragged on for years. Only time will tell. What does the lawsuit mean for the crypto community? The entire cryptocurrency industry is watching the Ripple versus SEC lawsuit, as its output will establish a precedent. The findings of the lawsuit will also help clarify the regulatory landscape for future ecos. It's not just the Ripple community that's concerned with the findings of the Ripple versus SEC lawsuit. The case can set a strong message for all involved in the cryptocurrency industry, besides XRP holders. The lawsuit's outcome could mean different results depending on the country. However, the U.S. would have its special status for cryptocurrencies. We hope you enjoyed this video today. What do you think about the Ripple versus SEC case? Do you think that it will end soon, or will it keep dragging on? What do you think the outcome will be and the overall impact on the cryptocurrency space? Let us know in the comments. If this video provided you some value, please like and subscribe. It would mean the world to our channel. If you have any video suggestions or comments, please let us know below. We love feedback. We appreciate your time, and thanks for watching.